for personal reasons, wants to have their property rezoned, one individual, and that the general public, but by a large majority, are not in favor of this. And we have seen nothing to prove that this is in the best interest of the county residents. Thank you.
Thank you. Okay.
Thank
you. Back to the council for action on this item. Mr. Estate.
I'm sorry, can I speak? Tracy Taylor, Heber City. I'd be very short. I was made aware of this letter. I looked into a little bit. I looked up the codes. My concern is there's been a formal notification to the county council and the county attorney that there are some concerns about following some state and county codes. I think it's only fair that the citizens get a detailed explanation from our county attorney on some of these issues, which in some cases are documentation. We either have it or we don't. The Planning Commission was supposed to have an impact study done, a fiscal and a legal impact study done before they could vote on this. I was sitting in that meeting. I did not see that impact study. There's some other issues such as that people were supposed to be responded to in writing for all their comments, whether written or oral. During this whole process, they were supposed to be responded to in writing per state code. That was not done. I would like evidence that these responses were done in writing. So, I mean, that letter is very formal. It's signed. It was submitted to at least 2 weeks ago to the county council, and I think we should all just take a breath a minute and decide, moving forward, if you move forward with this vote, that you are ignoring a formal written complaint about some process and whether you followed state and local code. Thank you.
Thank you. Mr. Sweat, we have a written response, correct? We feel like we've addressed those concerns internally, I know. So
you sent us a letter and asked us to respond to it. As an attorney for the county, by law and by my ethics, I represent the county and in that vein the council. So when I give a legal opinion, I have to give it to my client. I'm not allowed to give it to the other side or to anyone unless there's a privilege involved, and the privilege goes to the client. And so when I give it to you as a council, I have to say, that's your privilege. You get to decide what to do with the privilege. I don't get to decide.
Okay, then thank you. And we have that. Mr. Goode, that request came through you. Do you have any comment on this specifically, or should we just...
So I received a letter from Ms. Crittenden. I passed it on to the county council and to the county attorney. And county attorney responded to us on, I can't remember what day, it was just a few days ago, when we received the response. I'm okay going through these point by point if you'd like.
Why don't we? I think that would be better response. All right. If you're okay with doing that.
Well, I'd like the attorney to do it. It's their answer.
Okay.
So, just for a point of clarification, maybe not everybody agrees with what our county attorney's office has come up with, but remember, it was the voters who elected our county attorney and asked the county attorney to give the advice to this council. All right, so it's important in my mind that we listen to, that I, as a council member, listen to the voters who told me to listen to the county attorney. And I respect the attorney's opinion for a variety of reasons, with that being one of them.
And you put me at a slight disadvantage because I had someone in my office do that research and write that. I don't have a copy of that with me, but I can get it and going through it. I've read through it, but I'm not ready to present on it today and say this or that.
I think it might even make sense to send it to those folks who signed the letter. It's in response to a letter. I don't think we need to get in a anything other than respond to their letter like they've asked us to do. And we've done that internally. We can get it to them.
And I'm happy to do as the council asked. I would like to be able to be prepared.
Yeah, John, I think John prepared that letter, and I agree with you. So.
But, excuse me, if you're planning to vote on this today, how will receiving a reply to our letter help?
If
In-
we're
if we-
comfortable
in a week
moving
or so.
forward, good, bad, or indifferent with our attorney's opinion, I guess that he responded to the letter that was given to us.
Right, but-
And
but-
if we're comfortable, if we're not, then we would vote not in affirmative.
But that wouldn't give the members of the public who've written this letter the chance to review his response and then respond to that.
But remember, the response that the county attorney gives is, I mean, we'll make it available to everybody in the public, but it's to advise the council on whether or not we're taking the proper action. Whether or not you agree with the action that the council takes is a different animal.
Exactly. So,
We're all passionate here about things we do and folks we talk to, and so we need to be, and I'm very sensitive, whether you believe it or not, we're all passionate about, some of us property rights, some of us open space, some of us thinking that it opens Pandora's box, some of us thinking that it's responsible. And so we all just care. We're not trying to hurt anybody's feelings. We're not trying to be disrespectful. We just sometimes have different opinions. And hopefully you can respect ours, and we certainly respect yours. I disagree that we haven't listened to the public. Talked to lots of folks who believe that 5-acre zoning on a city boundary is very responsible with 98% in agricultural production after building homes, right on the city boundary. So to say that we've only haven't listened at all, I think that's unfair. We've had 4 public hearings, 6 or 7 public meetings where this has been addressed, and we've talked about it. We're not making this decision lightly. I'm not. I'm certainly not.
Well, and I just want to make a point that superseding whether you're for or against this motion, whatever the motion may be, is whether you followed state and local code.
Exactly.
And so that hasn't been proven yet, that these issues...
We have received opinions saying they're giving us their opinion so we can make a decision.
Have you seen an impact study done? Legal and fiscal impact study done as a council? I think that's a fair question to ask, because you're obviously privy to information the public doesn't have copies of at this point.
I don't remember if that was part of our packet or not. Doug, do you remember if we did
see that in
the impact? What was the other thing you said?
Fiscal and legal impact study.
Did we do that as part of this process? Do you remember?
There was an email I saw that was from our clerk's office and the attorney's office. I haven't physically seen those in an email.
We do those on developments. I don't recall ever seeing one done on a boundary change or zone change, general plan amendment.
It's something that is supposed to be looked at, yes.
On a development.
Yeah. Well, not on a rezone.
We've done fiscal impact studies on a lot of developments. Okay, come back to the council for action.
I would like to go back to this wetland issue.
Could you please make your state your name so we've got the.
So my name is Carl Sapp. If you look up the wetland on the wetland area map, which I have here, I could show you. It comes through here and it comes through the southern portion of this property. So I don't see how this was not taken into account. I mean, the whole reason for the A20 zoning was to protect wetlands. This property is obviously part of a wetland designation. Has there been a study showing that that was inaccurate? Has the Fish and Wildlife, the DNR, who's been involved
You'll
in
drive
this?
down and look at it, that entire 20 acres is in alfalfa production.
Are you a wetland specialist? Do you work for the Department of Environmental
That
Quality?
won't be
Well,
entire
maybe.
I'm going off of a map provided by Utah.
We've got your
DNR.
We've got your comment. Did you state your name, please?
Yes, I did.
Okay. We've got your comment. We appreciate
Has it
it.
been studied or looked into, or what?
We have maps, and from the Army Corps of Engineers, there are no wetlands there. That we have on file.
Remember, those other federal agencies?
Yeah, and Fish and Wildlife has that. That's the Army Corps of Engineers. Again, I'm not sure what you're looking at. We don't have that. Thank you, though. Appreciate it.
Want me to send it?
Well, we still haven't addressed the fact that they have.
My email.
I know, I brought that up, they didn't even talk about that.
We were looking at, it was from 94 to 2004, the water, what was that?
I had a study in
Hey,
the
please,
pack,
hey, please come to order.
and it was, I think it's map 26, so you remember that map? The wetland delineation map.
I've got it in here. Let me find it.
No, 26 is the flood hazard and problem soil.
25 is the wetland map. Okay, the Fish and Wildlife Service, can you tell me, is that state or federal? That's federal. So that meets the state qualifications for consideration by county
Okay, we're going to come back to action. Mrs. Kosokowski, did you have a comment?
I did, yes. It's,
Go up to.
yeah, my name is Kosokowski, and this is not just a matter of state and local law. It's also a matter of federal law, having some discussion about wetlands. Wetlands are governed by the Clean Water Act, and it's very specifically Section 404 of the Clean Water Act. Wetlands are considered waters of the United States, and that may be hard for people to understand because you cannot float a boat on wetlands, but they are waters of the United States. And so you have to, as Doug said, consult with the Army Corps of Engineers and get what's known as a jurisdictional determination letter from the Corps. And if it is determined that you have wetlands on your property, then you have to go ahead and get a dredge and fill permit. Now the kicker here is that usually it is 5 acres that is the cutoff point, whether or not you have to officially go to the Corps. And so since this is a 20-acre parcel, someone would absolutely have to go to the Corps. If you divide it up into a 5-acre parcel, then they probably don't have to go to the Corps. But it would be very easy to argue at some point in the future that this dividing up into 5 acres was done to circumvent that Section 404 jurisdictional determination process. So it is a matter of federal law. It's not just state and local law.
Thank you.
How difficult is it to get one of them determinations?
Well, you have to go to the Corps. They have to come out and they have to survey your property.
Have you done that before?
Yes, we have. The Army Corps is in Bountiful, and we can call them or send them aerial photos. I suspect they would look at this, and I don't know if they'd want to come down and look at it closer, but maybe they can look at it from an aerial and determine that it's not wetlands.
Okay, thank you. Okay,
All right, Mr. Chairman, I have a motion that we deny ordinance number 1801 as presented.
okay, we have a motion by Mr. Goode. We have a second.
I'll second.
Okay, we have a motion by Mr. Goode, second by Mr. Nelson. Any discussion on the motion? Okay, we'll vote. Mr. Nelson?
Yes.
No. More discussion, I should have brought something up.
Go ahead.
We've been working on this for some time now, since July. We want to deny this. This would be a first reading, is that correct?
We haven't
We
even
would
done an
approve
ordinance.
it.
As written, yes, because we have, no one's seen this until today, the final language, so I would say yes. Yes, that's not my vote.
Right.
This being the first
Do we have
reading,
him on the record?
this being the first reading would the answer, I think, yes, this would be a first reading.
So adjustments could be made along the way, because we're just the first reading for it approved.
I believe so.
Okay.
Yes.
What's that?
We could, if we decided to do this as a first reading, we could make adjustments to this and come back.
Yes.
Okay, no.
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 Yes.
Okay, motion fails.
All right, I have a second motion. I have a motion that we table ordinance number 1801 to November 7th. I think that would
November
give-
7th?
November 7th. I think that would give us an opportunity to address a lot of the things that we may possibly be missing, and it also would put us in the November window for making the change.
Didn't we already go through that?
I'm just making a motion.
Yeah, I think, okay. Motion by Mr. Goode. Do we have a second? Motion dies for lack of a second.
Mr. Chairman, I'll make a motion. I'll make the motion. We approve the first reading of ordinance number 1801 and have Doug request a review of this parcel by the Corps of Army Engineers to determine if there's any wetlands located on the property. And table this motion, table this action indefinitely until we hear back from the Corps of Army Engineers.
Can we do a date certain?
We don't know when.
November 7th is a good day.
Well. Come back. If we set it, say, 2 months out or a month out, then we can, and then we don't have
What
it.
kind of time frame have you?
It just costs money to redo it again.
They can be fairly slow.
Mr. Chairman, I just comment
We're going to
on,
have discussion about the motion.
we have a motion.
Wait just a second. Let me. Okay, we have a motion by Mr. Farrell, and your motion is to continue it indefinitely until we have
First reading and
This is the first reading.
first reading, and we continue it until.
And let's give the Corps 3 weeks, so let's do it the final meeting in May.
So be the third reading
Set a
in May.
deadline to the,
That's,
What's that date?
what would that be?
The 16th.
Okay.
Continue to May 16th, and then we can redo it again if we don't have it.
Right.
I second that motion.
We have a motion by Mr. Farrell and a second by Mr. Crittenden. Is there any discussion on the motion? Is everybody clear on the motion?
Yeah, let's just.
what about the letter from the people? Are you going to reference the letter from the people and the code violations?
No.
Okay,
I'm sorry, there was two conversations.
Sorry.
What was that? Yeah.
Well, just to clarify, that this can go to 3 readings.
Correct.
Yes.
And we can make a decision at the second reading if we'd like, or we can table it, or we can even decline it after the second reading if the results came back that there were wetlands. Okay.
I'd also like to make a comment that we can be okay with the boundary change, but maybe not okay with the zoning change. Some of our votes may need some more convincing on the zone change. I think the boundary change is a nice thing to make it a straight line and an obvious spot.
A straight line
We
is
have a
not
motion
always
by Mr.
in the
Farrell
best
and a
interest of
second by
anything.
And a second by Mr. Crittenden. Is there any further discussion or clarification on the motion?
Yeah, Mr. Chairman,
Yes.
can I make one other comment?
Sure.
I think that, I think it would be good practice by us at some point as part of this process to publicly respond to the concerns that have been expressed here in some way.
Okay. Mr. Farrell?
I got another motion after we vote on this one.
Okay. We have a motion by Mr. Farrell, second by Mr. Crittenden.
you want this one to?
We're going to vote.
No,
Yeah.
I want to clarify how we respond back.
Okay. We have a motion by Mr. Farrell, second by Mr. Crittenden. Any further clarification or discussion? If not, we'll vote. Mr. Nelson?
Yes.
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 No. Motion carries 6-1.
Now, I would like to request, maybe not request, that we okay the letter that we received from our council. We sent out to the signatures on that letter that we received.
Yep, I agree.
I'm okay with that.
Anybody got any issue?
I'll second that motion.
Okay. I don't think, did you want to do that by motion?
No.
Okay, I think let's agree that that goes back out, so.
Is it possible to make another comment?
Please.
What about
So what about the response to the people who spoke at the meeting on January 17th? I spoke at that meeting and I never received any response. I don't know if anyone else is here who spoke at that meeting. I know there were quite a number of people who spoke at that meeting, but it also, Section 17-27A-4044B of the Utah County Land Use Development and Management Act requires the county to respond in writing and in a substantive manner to any comments submitted as a result of a public hearing held to consider an amendment to a general plan. As documented in the minutes of January 17th, 2018 meeting, several individuals, it was more than several, testified, and several comments were submitted to the county council during and prior to that meeting. To date, the county has not responded in writing to these comments, which it must do prior to going forward. So,
in our opinion, which you'll get a copy of it from the county attorney's office, first off, when we have a public hearing, we are not required to respond in writing to all those who comment at the public hearing. If council members have a comment to make relative to the comment being made by a member of the public, we can do that in the meeting.
well,
That's a
it
state
says,
We
code
don't have to
stuff.
respond in public writing. The other part of that is, as our county attorney looked at what you're referring to, the only time we have to make a public comment on that is if it has to do with nuclear waste storage.
No, that's not
Which
true.
obviously it does not. So you can read it in here and then evaluate it, whatever. That's the opinion we got in this concerning this issue from the county attorney's office.
so are you saying that this is the wrong wording? That the wording
The
of
state
this
code's wrong?
section is wrong?
I've not looked at, our attorney looked at it, and that was the reply we got
Hold on just a
from them
second.
concerning this question.
Mr.
And you'll get it.
Mr. Sweat, will you take this under advisement and please send us an email in response?
On
This, so
this
we can
issue?
get back to her in a
Well,
timely
on
manner.
the question of whether the language in this is correct or not, that this section which I just referenced does or does not require the county to respond in writing and in a substantive manner to any comments submitted as a result of a public hearing held to consider an amendment to the general plan. Because if it does, then it seems like the county council should have responded to the people who
We've got a lot of
commented.
work to do, if that's correct, for sure.
Yeah.
Mr. Sweat,
Well, it wasn't done.
will you either respond or if you need
And I
to.
think there is a response in that letter, and so when it
Were you a
goes out-
signature on the letter that was submitted?
Yes, but I also commented at the meeting on January 17th, and I never received anything in writing.
I think when each of us made a vote, we each commented on our position and where we stood and why we stood on.
Well, it says in writing and in a
As
substantive
I said,
manner.
we don't have to respond in writing to every comment made in a public hearing.
Did you respond in writing anywhere?
Well, we've got this one that you're gonna get.
What?
The comments, the response to the letter that you guys
All right.
signed.
Okay, ma'am, thank
So it
you.
hasn't happened yet?
Thank you, no.
No.
Thank you, ma'am. We'll get
hasn't.
back with you in writing via the letter of attorney. Thank you. Okay, thank you. We'll get through this. We're going to take number 3 and move it to number 2 because it's in relation